following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the Notaries Ordinance of Sri Lanka and its recent amendments. Issues such as fraudulent documentation has been a long-standing obstacle Sri Lankans have had to face when dealing with legal matters. The new amendments to the ordinance seeks to rid the system of such malpractice. How effective has it been so far, and what other gaps in legislature and practice do the amendments seek to correct? A very good evening to everyone joining us on Law, Land and Liberty, where we bring to you key events in the legal field and breaking it down for the layman. Now tonight we will be diving into the subject of notaries. I'm sure most, if not all of us, have had to undergo some process that required us to work with a notary, and we have a brief idea of what services a notary is responsible in offering. However, there have been a lot of changes made over the past few years to the law surrounding notaries, and to speak to us about this we are joined by attorney at law Nirodha, Kalansooriya, who has 20 years of experience in this field. Thank you very much, ma'am, for taking the time to speak to our viewers and to me today. Now, Ms. Kalansooriya is also a senior lecturer at Sri Lanka Law College, a lecturer at Kothalawa Defence Academy, and more specifically to this topic, she's also convener of the Law Reforms Committee for Conveyancing Laws at the Ministry of Justice, which was appointed by the Honourable Minister of Justice. So I'm sure we can get a very insightful take on this specific topic from you, ma'am. We're looking very much forward to it. Now, before we get into the discussion, here is a breakdown of what exactly we'll be touching on today. First, we'll be talking about the role of a notary in itself and getting down to the very basics. Next, we'll get into the amendments made into the Notaries Ordinance. And finally, we'll be discussing other amendment enactments that are related to this field. All right, ma'am, well, without any further ado, let's get right into this very vast and rapidly evolving topic, ma'am. Now, starting with the very basics, ma'am, if you could start us off in this discussion with letting us know who can be considered a notary and what really is a notary in its essence.
Thank you very much, Anuradha, for inviting me for the program. So, a very pertinent question because today, a notary is the duty of the notary, the role of the notary has been changed. Actually, previously, a notary is a person who executes deeds and, execute agreements and all that. But now the role of the notary has become more, expanded, and now the notary's role has been, led to the safeguarding people's, rights, and to that extent it has been expanded, Anuradha.
I see. So over the decades, there has been a various expansion of exactly what comes under the field of becoming a notary. Okay. So I think we should go for the next most logical question when it comes to notaries and their process, the legislature, ma'am. If you could guide us into what exactly the main legislature is when it comes to considering notaries.
Yeah, Notaries Ordinance, which is enacted in 1907, if you see. So that is more than 100 years ago, this piece of legislation is enacted, very archaic piece of legislation. So that is the main document, the main enactment which governs all the notaries in Sri Lanka. So if you see, even though that is the main document, main enactment, Anuradha, when a notary performs duties, there are many enactments that they will have to comply with, like, the Powers of Attorney Ordinance, the Last Wills Ordinance, and Registration of Documents Ordinance, number of documents that they will have to comply with. But there, the process as to what needs to be done, what should they comply when it comes to their profession, that is governed by the Notaries Ordinance.
I see. So it's while they are under the purview of the Notaries Ordinance, they have to come into contact with multiple other enactments in order to carry out their role. Exactly. So I'm pretty sure that a lot of us are wondering now. We know what the legislature is, we know how it came to be and how drastically the role has changed, but many of us might not be aware of exactly how a notary comes to be in the first place. What is the process of becoming a notary, ma'am?
Yeah. Anuradha, now there are two ways of becoming a notary. a layman, a person, if he is really interested to become a notary, he can sit for an exam which is conducted by the examination department. So then they once they get through the exam, they will have to practice, they will have to learn under a notary for 2 years. So then again they will have to sit for another exam which is conducted by the Council of Legal Education. After getting through that particular examination, they can obtain license. In a sense, they will have to take an oath and obtain license. So the other way is, Anuradhe, a person, an attorney at law, after passing through the exam, they can sit, once they pass the conveyancing paper, which is conducted again by the Council of Legal Education, they can apply for notary. So any attorney at law can apply for notary license. So then they will have to take an oath, and then they can, get the license. But the new amendments which is proposed the last year, according to that, this process will be changed. That is that any attorney at law, yes, they can apply for the notary, but the only thing is they will have to learn under a senior notary who is having minimum 10 years of experience consecutively to to practice, to commence. So in the sense now, if he wants to commence the practice, the junior notary, the junior attorney at law, they will have to submit the letter which is issued by the senior notary to the effect that that particular lawyer has studied with me for 1 year, and then that will have to be submitted to the Registrar Generals. Then only that junior lawyer can commence to work as a notary.
I see. So when it comes to attorneys and when it comes to normal people that are interested in becoming a notary public, it's 2 different processes, is it, ma'am? So then I have a question for you regarding that, where the amendment has specifically addressed attorneys at law when it comes to getting the notary public license. So could you let us know if that amendment affects the interested party that is not a lawyer that is willing to become a notary?
No. That is not affected. Those parties are not affected. So this change, because anyway they will have to practice under a senior lawyer for 2 years. But according to the amendment, an attorney will have to practice under a senior lawyer only for 1 year. So then only they can commence the work as a notary.
I see. So it's a little bit of an expediting of the process when it comes to being an attorney.
Exactly. The Anuradhi, the reason behind this was, now we have seen that there were a lot of frauds were happening around. So the junior notary should understand, to get the proper knowledge and the understanding of the profession and the gravity of it. So that was the reason behind it. So that is why the 1 year training with a senior lawyer was made compulsory.
I see. So earlier it wasn't compulsory, but we saw it unofficially in practice. So now we can confirm that it is required under the ordinance by law for us to undergo such an issue. Now I have a question once again regarding that, ma'am. Now, those who have already obtained notaries public licenses that may or may not have undergone training under a senior lawyer, how does that affect them?
They won't affect Anuradhi, because this is the amendments were enacted in last year. But for them also it is better if they could practice, because in order to get the knowledge, because now, as I told you in the beginning, so this area has been expanded. Now there are a lot of things to check. Earlier it was just to check the title and attest a deed, but that has been changed, Anuradhi. Now today you have to check a lot of things, like when you execute a deed, the coast conservation things, and then BRO reports, and everything has to be checked. That is not just checking the title and execute a deed for your client. So that was the reason. So
because of the intricate process that comes with authorizing something through the signature that a notary public can provide, there is a lot of stringent regulations in place. Now, ma'am, I have another additional question regarding that. Now, when it comes to the notary's ordinance, it has been in place for over 100 years. So why are we just now seeing such rapid amendments to the ordinance?
Very interesting question, Anuradhi. Actually, this particular legislation, the amendment was the Nirodha. So it has been changed several times. In 2011, there was certain amendments for certain sections, but this particular, the amendment for the notary's ordinance was required because of the due to the so many fraudulent transactions that were happening around the country. Because of that, people's hard-earned money. Now we know that purchasing a house is the entire the person's entire lives. Now they have earned a lot, and then that money, the hard-earned money, they used to purchase. And because if we do not do a proper job, if we cannot do, so then that is a waste of his money as well as our time. And in order to attract investors, our registration system, our land registration system has to be perfect. So in order to cover these two areas, in order to protect our citizens as well as to attract the investors, so this particular legislation had to be amended. But we were discussing, I think if I remember correct, in 2015, since 2015 we were discussing how to amend this, but this has not been, that was only a dream. But finally in 2019, it was decided by then Minister of Justice, Salisa Brace, so the President's Council, to amend this. So accordingly, so a committee was appointed and the changes were proposed. Actually, Anuradhi, these changes are not, it was not actually changed because as prudent notaries, we all were practicing these things. If you see now, when you execute a deed, we used to get a photograph of the signing. So it is just to be a prudent lawyer, ensure that one fine day they can't come and tell, no, we were not there, they cannot deny. So you used to take a photograph. So now it has become, now photos are fixing photos and all these things. So this is not a novel thing. All these are practices which were carrying out throughout the day to become a prudent notary, but it was not there in the enactment. But now we collected everything, and now it is in the piece of legislation as an amendment.
All right, well, that means there has been a lot of reform that has been done in the field, but there is still a lot more to cover, especially when it comes to the amendments aspect of the ordinance. But before that, let's take a very short commercial break. You're watching Law, Land and Liberty. Stay with us. Welcome back to Law, Land and Liberty. We were in discussion with attorney at law Nirodha Kalansooriya, and we were talking about the Notaries Ordinance, and we got down to the basics of exactly what a notary is and what amendments have been made in becoming a notary and what practices are now solidified in the law, ma'am. Now I think it's a very good segue for us to get started into the other amendments that have been made in the field. Now, before we get into the actual amendments aspect of it, I think it's important for us to get a deep understanding of exactly what the reason was to bring these amendments into place. Now, as we already learned, these were practices that were carried out by prudent lawyers, regardless of it being in the law. So now, why now has it been enshrined in the law? What is the reason, ma'am?
Anuradhi, as I told you before, it is to safeguard our clients as well as the notaries, because when you perform your duties, it is a requirement that you also should be safeguarded, because this is a profession. So we have seen that when fraudulent transactions were happening, so notaries had to go to police stations and make statements. So they also was in an uncomfortable situation. So because even though they have done their job properly, if the fraud happened, because sometimes due to impersonation, so due to the fraudulent signatures, so that a notary cannot identify at the time of signing. So due to those reasons, they had to go to the police stations and make statements. So in order to safeguard the notaries and also to safeguard our clients, these amendments were proposed. Actually, because we have seen that a lot of fraudulent transactions were happening around the country, and so there were no way to safeguard our clients. So the lands were difficult to, you can't trust to how to purchase the land. So you have to go to a lawyer, you have to check, the lawyer should have checked. But then again, it is a very scary situation to purchase the land. So in order to cover all these situations, because even though the practices were there, some were complying for those practices, some were not. So therefore, it was the need of the hour to bring these amendments to the ordinance.
I see. I mean, of course, I'm pretty sure a lot of us that is watching right now will have come across such situations where they have been handed fraudulent documents, where they are hoping to purchase a piece of land and it is actually fraudulently authorized by a notary public and it is not legitimate. So I think we should get into the specifics, ma'am. You mentioned a fixing of photographs and issues of fraudulent documentation. Now, I think it's important for us to exactly understand what key areas were attempted to be amended in the notary's ordinance. If you could get into detail about that, ma'am.
So, the few amendments, I mean, few important salient things I will discuss with you, Anuradhi. One is that in addition to the signature of the person, the thumb impression, it can be a thumb impression or any other finger impression or toe impression, was the requirement to place it beside the signature, because the signature can be forged. So, in order to safeguard the client and the notary, the thumb impression had to be placed. Now, according to the new amendments, it is a requirement that thumb impression or whatever the finger impression or toe impression has to be there. And again, the transfer, in a transfer deed, we have seen that generally the seller has to sign the deed of transfer, not the purchaser. So what happens is, now when you place the seller's signature, when you do the later transaction, we don't know the purchaser's signature. So therefore, these purchasers and the seller's signature both were a requirement. Additionally, Anuradhi, now according to the notary's ordinance, the person, the notary who is executed the deed should know either one of the executant or the witnesses. And the witnesses should know the executant. So generally the transfer deed, as I told you, is signed by the seller. So in good old days, notary is confined to a certain village. So he or she knows the people who lives there. So he knows all the people. But now the profession is expanded. So clients are coming various parts of the country, and the first time we see them. So, and sometimes we know the purchaser, because purchaser is known to us. He comes and tells us, please execute the deed. So we don't know the seller. But when the deed is signed by the seller, so how can we say that we know the seller? Because the purchaser is the one who is coming. And therefore, now according to the amendment, either of the executant, now the seller also will have to sign and the purchaser also will have to sign. So either of the executant should be known to the notary. So that is fair enough for the notary or the executor or the witnesses, and or the notary can check the national identity cards as well. So these are the few changes that has been brought into the notary's ordinance. Additionally, you may have seen a photograph, passport size photograph has to be affixed to the original. Actually, we proposed it to be affixed to the protocol. There are 3 copies of deeds to a notary. So protocol, but now it has to be affixed to the original. Some lawyers, we have some notaries, you have seen that still they take the photograph as previously. So photograph has to be in order to identify, because later on the person cannot deny, now I have not signed the deed and all that, now they can't tell. And so the future confusion, to avoid those things, Anuradhi, these things have been brought. And so passport size photograph has to be placed, the thumb impression has to be placed. So all these have been done according to that. And in addition to that, if a corporate body executes a deed, a company, so they will have to submit their incorporation certificate and the board resolution also to be annexed to notary's documents. So another very important thing is that you may know, according to the notary's ordinance, there is a way of executing deeds without checking the title, search dispensed with. So at that time, the law, if the client says, you don't have to check the title, please execute the deed, I am in a hurry, I want to purchase the land. So then what notary does is, he or she won't go to the land registry to check the deeds. So he just put it search dispensed with on the deed and execute the deed. So that is removed. Now, for each and every transaction, you will have to check the the land registry records, because that is very essential. We don't know what is happening there. So we just execute the deed, because laymen, they don't know the gravity of it. So now that has been brought into, now the notary should take the last entry of the the records at the land registry, a certified copy, and they will have to keep it with them. And also the national identity cards of the the parties, they will have to keep with their protocols. So one fine day, if something happens, if the party denies that I have not signed the deed and all that, notary has all the things to go to the police station and produce. So that was there before, I mean, as a practice, but it was not in any enactment. So they were, there was no any, to safeguard the notary. Now everything is there in the legislation. Now you can tell you have adhered to the legislation, you have complied with, and without any fear, you can go to the police station and you can, tell them that you have done the proper job.
I see. So there's a little bit of a shield for the notaries as well. Exactly. When it comes to documentation that is not exactly legitimate. Just a little add-on question to that, ma'am. Now, you mentioned that ID copies are being taken as photocopies maybe that are signed as originals can be taken. Now, I have a curious question of why we need both an ID copy as well as a separate photograph. Is that required that it's two separate things, or I see? So there is a...
Because Anuradha, it has to be a recent photograph. So your IDs may be, old and you can't identify. So that is what is happening. The impersonation happens all together with that. So a recent photographs, then that is there, and that has to be certified by the notary as well, and that has to be affixed to the deed. So
I see. And also adding on to that, ma'am, the whole signing on the blank sheets of paper issue, is that also addressed under the ordinance?
Exactly. It was anyway there. I mean, you can't get signatures to the blank sheets, but that is also amended. Now you can't, and in additionally, you have to put the page numbers. So if these things, Anuradha, we have been doing, but now it is in the enactment. So you have to number the pages, and every divided page you have to get the signature of the client. So those things, and as you said, it has to be a durable paper, the parchment paper. So you can't take on A4 sheets the deeds and all. Exactly, it has to be a legal sheet. So you can keep the deed for, because this is a deed, you have to keep it for a lifetime. So those things are included. Those things were there, but those things are now in a piece of legislation. Is the difference that has been.
So that it is a more stable ground for both the notary and also the client. And finally, ma'am, I'd like to ask you a little add-on question for that, a sub-question, if you will. Are these amendments retrospective in nature when it comes to issues, or is it solely for the future?
For the future, from the date that is executed, enacted.
So now I think the most important question I feel like the viewers might have is there now, with all the reforms that have been taking place, is there still room for more reform, ma'am, when it comes to the ordinance?
As far as according to the, when you see the amendments, most of the things are covered, but Anuradha, it has been noted that certain, certain amendments, when notary execute deeds, certain amendments are, little bit strict and all that. So we are in the process of amending those things, because for an example, now both parties will have to sign the deed. So in certain like mortgages, if you see the bank, when you take a loan, the mortgage fund has to be executed. So when that has to be signed by the both parties, then the directors of the bank also will have to sign. So those things might be changed, because that is not required. So little things might be changed. We have proposed those things. Other than that, to mitigate the fraud, I think we have taken almost all the steps which can be taken within the country.
Of course, I mean there is a lot, as we already discussed.
Yes, because that was the reason when we were doing the amendments, we had these several discussions. So how to safeguard the notary and the customer, because we have to safeguard ourselves as well. Because that was the main reason, because we are helpless when we go there. There is no one to safeguard us. We have to tell that we did all these things to we didn't want to do a fraud. We did all the things to safeguard the client. So I think we have taken almost all the steps to cover the customer as well as the notary.
So in your opinion, ma'am, it does not look disproportionate.
Exactly.
So then we can definitely, now that we have a comprehensive understanding of exactly the Notaries Ordinance and how the amendments have actually impacted the legislature, which I'm sure a lot of us were willing to find out about, because having a notary authorize your deed or whatever documentation is a very important legal process, and a lot of things depend upon that single signature and that single authorization. So I'm sure a lot of us will be resting at ease now with the already practiced unofficial customs done by notaries already enshrined in the law. So I think this would be an appropriate time for us to get into our final segments, which would be other enactments that have been amended. But before that, let's take a very short commercial break. You're watching Law, Land and Liberty. Be right back. Welcome back to Law, Land and Liberty. We were in conversation with attorney at law Nirodha Kalansooriya, and we were talking about the Notaries Ordinance and the amendments made to the Ordinance. Now, I know we are supposed to be going into other enactments, but there's a little bit more when it comes to features that were amended that I'm sure the viewers will appreciate in understanding. So let's dive into specifics now, ma'am. When it comes to the amendments, the most important area that a lot of people will pay attention to is the fingerprint. Now, we usually, even for important financial transactions, we never really have to place a fingerprint. So we have the obvious question now, why now do we have to place a fingerprint and a signature? So if you could just get into the specifics regarding that, ma'am.
Yes. Anuradhi, there were two schools of thoughts for this. So we have been discussing this, as I told you, from 2016, the amendments were, we were discussing and all that. So the fingerprint was an issue because there were two schools of thoughts. Some lawyers said that this is when the fingerprints are taken when a person is, acquitted for criminal offense. So why you all are taking fingerprints for the deeds? Because this is just a civil matter, right? So why? But some of them said, no, the fingerprint is required. So why we, insist on the fingerprint is that, so it is different to person, and one fine day if you check the fingerprint, that person cannot deny that he has not signed, because that is what is happening. They sign the deed and they deny they have not signed, or else they just put the fraudulent signature. Now that cannot be done because the fingerprint is also required. So now the fraudulent person cannot place the fingerprint. So, and this is not only confined to our country. If you see India, the fingerprint is required, and even Indonesia, they have the requirement of placing the fingerprint to the deeds and documents. So that is how this fingerprint came into operation. And when we had discussions, even then minister, because this was a big issue, the placing the fingerprint, because you have to get your fingers are have to place, and if it is a company, if he or she is a company director, he will have to place the fingerprint impression and all that. So it was a big huge issue. So then Minister of Justice, and even now Minister of Justice, Mr. Ali Sabri, President's Counsel, and Mr. Vijaydasa Rajapaksa, President's Counsel, so both of them, honorable ministers, both of them agreed that fingerprint has to be there. So this is a requirement. So that is why, so this requirement was included into the piece of legislations. They said this has to be there because otherwise we cannot eliminate, mitigate the fraud. Because they will find some other way to do, and these frauds, Anuradhi, is not the person is doing. So they get together, that's a record, right? So they, from the land registries to, and they take the lawyers, the deeds, the lawyers, the notaries who dead and gone, so those deed numbers they take, and that's a scam. So that is how they do this. So in order to, if you want to avoid this fraud, certain stringent regulations has to be placed. Even some people may like, some may don't like, but have to take a decision. So that is why this has been, brought into.
So despite some people arguing that it is much too stringent. It's after all a measure made for safety as well. Now, just a little add-on question, just like I asked in the previous segment, ma'am, when it comes to that retrospective nature. Now, we have currently, when a notary is going to authorize a document, it's going to be a signature and a fingerprint, as well as, of course, an image, a picture, a recent photograph. Now, what does that tell in reflection to previously authorized documents? Does that make it less sufficient? Is there a need to redo these things, or?
No, Anuradhi, I mean, that was there. I mean, we can't, we can't make it retrospective. So, but I heard some lawyers, they, as a, precautionary method, they were taking the impression, the thumb impression on their protocols. So some lawyers have been, notaries have been doing that, but that is okay even if you have taken it or not, but that was the practice before. But going forward, we have to be, mindful of this fact. We have to get the thumb impression or the impression, because not only the thumb impression or any other fingerprint, because of the war, we know, Anuradhi, several people, they have lost their hands. So we can't, insist on thumb impression. So even the toe impression was brought into the amendment because of that. So now any finger impression you can place instead of, or the toe impression instead of the signature. So previously it was not the case. If you can't place the signature only, the left thumb impression you can, place onto the deeds. So now the situation is different, and according to the new amendments, you will have to comply with that.
Of course. Now I think I should get into another specific area that we were not able to discuss in the previous segment that ma'am, you would have rightly pointed out when it comes to the financial aspect of a deed or even authorizing something, the stamp duty fees. That is a very consistent, it's a very contentious topic when it comes to notaries and also the general public, because you're essentially handing over your money to someone that you would entrust in order to pay such fees. And we can't really do that by ourselves. We need a notary in order to guide us through the process. But I'm sure a lot of us can, not a lot, but a considerable amount of people might attest to the aspect of it being not as trustworthy, where there could be malpractice involved when it comes to the embezzling of such funds. So, ma'am, what measures have been taken by the ordinance through the amendments in order to combat this issue?
Yeah, so that's a good question, Anuradhi, because earlier, according to the enactment, the ordinance, notary should make sure that stamp duty is paid for the proper amount. So you can't, allow your client to undervalue it and pay the stamp duty. So that was there. But now it is the responsibility. A responsibility is cast on the notary to pay the stamp duty. It says notary should ensure that the stamp duty is paid for transfer deeds, gifts, blah, blah, blah. So you have to pay. That is the responsibility of the notary, not your client. So you have to pay the stamp duty. So that is made, ensured. Additionally, Anuradhi, there is a requirement of registration. Now, according to the registration of documents ordinance, the registration was not mandatory, but after registration you got the priority. So indirectly, registration was mandatory. But now the registration is mandatory. You have to send the deed within 30 days for registration. So by doing that also, that insists the notary to pay the stamp duty within the 30 days, because you have to send the deed for registration. And once you pay the stamp duty, the receipt has to be affixed. Now previously it is to, you have to affix the receipt to the duplicate and your protocol. Now a true copy has to be attached to the original as well. So if you want to send it for registration, you have to send it for registration within 30 days according to the amendment. So you have to pay the stamp duty indirectly. So it insists the notary to pay the stamp duty within, certain period. And so as a proof, you have to place the receipt as well to the original deed. So those things, by, amending those things, the stamp duty payment has made compulsory, and also you can't, play around with the stamp duty also. You have to pay it.
All right, ma'am. Now I think we have a very comprehensive understanding of the specific areas that are impacting the general public, the client, when it comes to their protection and also the notary's protection when it comes to authorizing such documents. I think it's important for us now to continue on to the other enactments that are touched by the notaries and what enactments have been amended. So let's get right into the most, I feel like the most contentious, the most important area when it comes to the amendments that are touched by the notaries, which is the powers of attorney ordinance. Now, if you could just get us a little bit into exactly how the power of attorney ordinance has been amended and what these key features are that have been amended.
Yes. Powers of attorney ordinance is also amended, Anuradhi. According to that, the registration was also made compulsory, and within 1 month, if the power of attorney is executed in Sri Lanka, that has to be registered within 1 month. If it is a foreign power of attorney, so you have 3 months time period, because they have to sign it and send it back to Sri Lanka. So the registration was made compulsory, and if it is the power of attorney is related to a land transaction, the metes and bounds has to be stated there. So then it has become specific. So that is another amendment which has been brought to the powers of attorney amendment. And when you want to cancel the power of attorney, the procedure was very cumbersome previously. So you have to publish in the papers and all that to cancel it. But now by executing a deed, power of attorney can be cancelled. So then again there is a problem, Anuradhi, if that particular person is in abroad, how to get it cancelled, because then he will have to come to Sri Lanka to execute the cancellation. So in order to prevent that, what we have done was, that person who is in abroad can send a notice to the Registrar General saying that, so I will be cancelling my power of attorney until such time, please register this particular notice. So that will appear in the folios relating to the power of attorney. It is there saying, so this is going to be cancelled. So if someone before executing a power of attorney or before executing any deed, so we have to check if somebody comes with a power of attorney and we are going to execute a deed by using that, we have to go to the Registrar General and check whether that particular power of attorney is in force or not. So when you go and check that, there is remarks column, there is something saying that this person is going to cancel it. So it gives us alarm, and so we are not going to do that thing. So that provision also is included to the amendment about the cancellation, and the power of attorney is valid only for 5 years, because now there are very old powers of attorneys which has been using by our clients. So we don't know whether that the principal even wants to give that power to the attorney now, because they must be misusing it. So therefore the power of attorney document, the period of that particular document will be restricted to 5 years. And so if the principal wants to give the attorney more time, so he can execute after 5 years and can do the needful. And again, the copies of the national identity cards are needed, and the thumb impression. Now, if it is a foreign power of attorney, thumb impression you can't place because that person is in abroad. So other than that, so all other regulations are there.
So there is a lot of changes made in the power of attorney enactment that also ensure that the notary will ensure for a safer process, as well as the client being given what authority they deserve through the legislature as well. Unfortunately, we have run out of time to discuss any further regarding this topic, despite there being a lot more to get into. But I feel like this was comprehensive enough for our viewers to digest in one sitting and to really understand how the workings of the notary actually goes about. And it's not just someone that's licensed and signing on the paper.
One more important thing, if I could tell briefly, on the last will's ordinance also amended now. Last will is one which we are going to execute, expecting the death. So that we used to, there were provisions to execute it in front of 5 witnesses, but now that has been removed and it is repealed, and you have to go to a notary to execute a last will. Additionally, the caveat was another problem, which was a burning issue, because everybody was filing caveats to the lands, especially brokers. So because according to the act, anybody can file caveat. So that has been again repealed. The interested party only can file the keep it. So those few amendments also have been brought into the amendment.
Of course, so there is a much safer legislature now and a lot of not less room for us to have malpractices. So thank you once again, ma'am, for exactly explaining to our viewers regarding these various aspects of the law and especially helping us understand about the Notaries Ordinance and how a notary functions. Thank you very much for your time, ma'am.
Thank you for having me on the show.
All right, well, notaries can be considered a cornerstone in the legal sphere of Sri Lanka, as it is these licensed professionals that are responsible for the authenticity of more than just our documentation. Therefore, it is our duty as the general public to be aware of their role and their limitations in order to prevent malicious practices. We leave you tonight with the words of Ken Salazar, who is the U.S. Ambassador to Mexico. Each and every notary public plays a crucial role. They serve as our front line of defense, and the public is safer because of the job they do. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can always rewatch by catching us on our YouTube channel, youtube.com/Derana English. I'm Nirodha Vikramasinghe. Good night.